Hello and welcome to Runkle of the Bailey. Today I've got David Fraser, who's, I think, Canada's premier privacy lawyer. He is the guy who comes up over and over and over again. If you ask somebody, who do I go to for a consult on privacy issues, his name's going to be there. So this is kind of a niche area because Canada hasn't always been the best at privacy, but it's a good area to explore. And it's kind of a fascinating area. And we've also got a topic here that is right up his wheelhouse here, because we've got British Columbia is pushing through a new law, which may have its strengths and may have its weaknesses. I do criminal defense. He does privacy, so we may have a bit of a different take on it, but reasonable minds can differ, and we can disagree and we can discuss, because that's really where that's the most valuable thing, is getting those kinds of discussions. But this is Bill 12-2023, which is the Intimate Images Protection Act. So you had mentioned this one on Twitter and sort of commented on what it's trying to do. And we can talk about whether or not it's actually doing that, because I think we initially disagreed on that and now are probably more in agreement, it sounds like.
Yeah. Well, thanks for having me on, Ian. I appreciate it. That and this is a very interesting topic to talk about. And British Columbia isn't the first out of the gate on this. British Columbia is kind of the latest of a number of provinces that have come up with statutes to create civil claims for what's called the non-consensual distribution of intimate images, sometimes called revenge porn, which is also in the criminal code. It was made an offense in the Protecting Canadians from Online Crime Act, I think it was, that made it an offense to distribute an intimate image without the consent of the individual. And many provinces have statutes that are intended to create, I guess, kind of streamlined remedies for victims to get the content taken down and to provide for the possibility of damages. And certainly I've represented individuals who have been victims of this sort of thing. Nobody's in it looking for damages. They're all looking to get the images taken down. And from my point of view, a couple important things. I think we share something in common, which is that these need to be appropriately tailored so that they don't go overboard, so that they actually deal with the mischief that they're supposed to deal with, that they don't have kind of overkill with respect to freedom of expression, that it has to be properly balanced, has to pass the Oakes test, as we chatted about a little bit on Twitter. And be appropriate. And the one thing that I think distinguishes British Columbia's effort from the others is that the definition of an intimate image includes somebody who is depicted as being nude or barely nude or engaged in explicit sexual activity or those sorts of things. And I was thinking of it in the context of deepfakes, which is not something that is addressed explicitly in the criminal code or any of the other statutes, but is starting to become an issue with the use of artificial intelligence-based image manipulation and video manipulation for face swapping. You might have seen, or some of your viewers might have seen, the deepfake Tom Cruise on TikTok and on YouTube, some absolutely somewhat hilarious, but also when you think about it, that you could easily take somebody, an existing video, and in this sort of scenario, it would be an explicit sex video, and change the face and change parts of the bodies and change those sorts of things and do it entirely. I use the term synthetic. So entirely just kind of within the computer, you're not using an actual person. You might be using an image of them that's been found someplace else. And in instances that's not just theoretical, that's been done in some instances, and it's been extremely traumatic to the individuals depicted. And so these laws don't really go after that. And I think the BC one is trying to do that with the use of the word depicted, but perhaps hasn't gone where they need to go. But in some cases, as you've pointed out on Twitter and in our conversations, that the definitions and the qualifications related to consent and the ability to withdraw consent may mean that something like this can be used in circumstances that most of us wouldn't think of as being appropriate cases where these sorts of civil claims should even be available, let alone being used.
Yeah, I looked at this and First of all, the first thing is I don't think it actually properly captures deepfakes, which is kind of an interesting aspect. But I kind of wondered if this thing was actually aimed as being there to help the porn industry, because this thing seems to do a lot more to help the porn industry than most people. It's actually quite striking as to how this is how you'd write this if you wanted to help out that industry, which I don't think that's where they're going, but it's really kind of where they end up. So I guess we should talk a little bit about some of the definitions. I can pull up the law here. So claimant is an individual depicted, in an intimate image, and applicant is anybody who brings an application or an individual depicted. Depict is going to be an important term here. So to represent in a recording of a still image, a recording of a moving image, or a simultaneous representation. Now, that one's kind of interesting because it does specify a recording of a still image. And that seems like it might affect some deepfake stuff, but not others. In the sense that if you are creating something by editing an existing picture, that might count. But if you're creating it by just having an image generated via, say, an AI, I don't think. Would you agree with me that it doesn't seem to fall in there?
Yeah, certainly if they intended to make it apply to that sort of synthetic AI generated imagery, they should have been a lot more explicit, because it's not. I can see hints that they wanted to go in that direction, but I don't see anything that would clearly guide a decision maker with respect to, oh yes, this was intended to go after that sort of mischief.
And it's kind of interesting because this is getting to be sort of more noticed because of AI and all of this technology. But this isn't the first time it's been possible to depict somebody as nude or engaged in a sex act without their consent. Because really, if you've got the skills, you can do it with a pen. So this is there's potentially a lot of stuff out there that could be affected by this that isn't sort of deep fakes, but is also just like editorial cartoons. If you look at editorial cartoons from like the 20s, a fair number of them depicted politicians in states of undress or states of embarrassment or other things. It's less in fashion now because typical newspapers have become more of a sort of family-friendly thing. But if you look at older publications, sometimes they were quite explicit on that. And I wanted to bring up one just maybe we should go through the definition of intimate image before I bring up another thing here. So they say that this means a visual recording or visual simultaneous representation of an individual. So they mean some sort of basically any picture or video is really what that comes down to. Whether or not the individual is identifiable and whether or not the image has been altered in any way in which the individual is or is depicted as A, engaging in a sexual act, B, nude or nearly nude, or C, exposing the individual's genital organs, anal region, or breasts. Interestingly, they don't differentiate between men and women here.
Right.
So
some of the provincial statutes do, and I think that the federal statute actually does. And instead of using the male pronoun, as is commonly the case throughout the criminal court, it refers to her breasts, if I recall correctly.
Which is interesting because normally in a statute where they use a gendered pronoun, typically, unless it's specific, that can be read as referring to either gender. So that still creates the same problem, just in its own way. And in relation to which the individual had a reasonable expectation of privacy at, in the case of a recording, the time the recording was made, and if distributed, the time of distribution. And in the case of a simultaneous representation, the time the simultaneous representation occurred. So I guess a simultaneous representation would also include something like a live stream.
Yeah, and I think if you look just a little bit lower, you'll see that I think that's entirely what they intended it to be. So it means an image distributed through live transmission, whether or not the image itself is recorded. And
Yeah.
so if you go back to the definition of what is an intimate image, so I think that one of the things that, so at the beginning, it looks like it might cover deep fakes because it talks about as the person is depicted as or represented as, regardless of whether the image is altered. But the second part talks about the time, the expectation of privacy at the time that the recording was made, or at the time of the distribution, or at the time of the streaming. And if the victim is not at all involved in either of that, I'm not sure you can refer to an expectation of privacy in those particular circumstances, unless you're talking about the relatively obscure branch of privacy interests, which relate to kind of control over one's image and things like that, or the false light privacy tort. But I'm not sure that was their intention.
Yeah, it's very difficult to say because normally you wouldn't have an expectation of privacy in something that didn't happen.
Yep.
Right? It's normally that's intended to keep secret things that might have actually happened, but that you don't normally reveal to the public. Like if I go to the bathroom, somebody can't put a camera in there because I have a reasonable expectation of privacy. But
yeah, and so certainly, so the definition and the way the statute works would certainly apply to what most people think of, and the term that's often used with respect to revenge porn, with respect to like the actual depiction of an actual person, where two people in an intimate relationship share images or share video or kind of stream to each other, and then one of them betrays that trust and distributes it further. That image, that recording at the time would fit into the definition of intimate image, and you'd refer to the expectation of privacy with respect to that image or that recording at that time. So something that's completely synthetic probably needs a different category or a different definition.
And one thing that did leap out as would definitely be captured is, say, if you've got something where somebody takes an image and their face is covered, or where it's edited out. Like if you black out the face so that you can't see it, you just put a big, there's still an expectation of privacy in that image according to this, under this law, which even if they're not identifiable at all. So you could have a reasonable expectation of privacy, in that sense, in just like a close-up of genitalia or that sort of thing.
Yeah, and then there is in the privacy case law, a relatively obscure case with respect to kind of anonymized information. If the individual can themselves recognize themselves in the information, then it's not completely anonymous, and they still retain a privacy interest in it. So even if nobody else looking at it would know that it's that person, if that person knows it's them from seeing it, that they still retain a privacy interest. Maybe slightly different from what would ordinarily be the case with respect to kind of, everybody would clearly know that it is that person.
I mean, this could even go so far as even if that person couldn't identify themselves in it. So, and there's an image I wanted to sort of share here, and this is, I've censored it, notwithstanding the fact that it's classical, classical art here. And this is a portion of the Sistine Chapel. And the reason why I raised this is that this is Minos, and the part that you can't see is that Minos's penis is visible in the drawing, and it's being bitten by a snake. And this is basically because this face is actually the face of somebody known to Michelangelo, who in fact pissed him off. And so Michelangelo's revenge was to paint this figure with this face in a fairly humiliating kind of way. And apparently when this guy went to the Pope said basically, deal with it. Was kind of his, but he wanted to go to the law to say like, hey, fix this. And had this law been in place, he might have used it. So that I think is interesting when we look at this, because if we get to the point where we're covering deep fakes, how do we not cover something like that? And I mean, that to me is explicit, not just freedom of expression, but it's a higher form of freedom of expression because it's direct political expression. And there's also, I'm thinking of like the Trump baby balloon that people have, where they've got the genitals are part of what they're showing off there because they're trying to insult Trump by that means. And I'm going, would that be a problem?
Well, so much of this area really is a challenge of line drawing. Like the line drawing is absolutely essential in order to properly scope it so it survives the challenge related to freedom of expression and Section 2B that Nova Scotia came up with. This was a number of years ago, something called the Cyber Safety Act, after a number of a lot of publicity given to online cyberbullying, particularly of young people, and a number of instances resulting in the death of the young people. And they came up with a piece of legislation called the Cyber Safety Act, where the definition of cyberbullying was just so broad that it included kind of hurting somebody's feelings, harming their self-esteem by the use of
any sort of Twitter
media.
beef that you might have.
Well, that's right. And so I was the lawyer who acted for a respondent to one of these complaints, and it created a civil cause of action and a civil claim. And I'd said, look, this legislation is going to be found to be unconstitutional. I had the opportunity to argue in court that, in fact, it was. And the legislation was struck down under Section 2B, freedom of expression grounds, and Section 7, life, liberty, and security of the person grounds, because of the procedures that they had set out. And it really came down to that definition of cyberbullying was so broad. And at the time that was going through the court in Nova Scotia, the federal election was going on. And so we could easily attach to an affidavit a whole bunch of tweets talking about kind of Pierre Trudeau's hair or Justin Trudeau's hairstyle and things like that, and calling him a lightweight. And of course, that's going to hurt his feelings. But that's part of the rough and tumble of political discourse, in the same way that Trump balloon, it might be a little bit distasteful to a huge number of people, or to a large number of people, or to only a handful of people. But you need to make sure that the legislation is properly crafted so that it goes after the stuff that's actually harmful, that kind of in the Oakes analysis is kind of a pressing and substantial objective, and doesn't go after stuff that goes beyond those sorts of circumstances. And it doesn't turn people in. And I commented when the Protecting Canadian from Online Crimes Act was going through Parliament, I commented as an individual at the parliamentary committee and said, look, you need to go after the stuff that's actually culpable, and make sure that you're not including the stuff that's not culpable. And that same issue that I think we're about to talk about now in the BC statute is the issue that was kind of front and center. To what extent does somebody have to kind of confirm the consent related to an image? To what extent does somebody become reckless with respect to that image? And the BC legislation creates a presumption that if something's an intimate image, that there's no consent. And I have it on reasonably good authority that there are pictures of naked people on the internet, and a significant number of people put that there themselves.
I'm horrified.
Well, and there's a significant number of kind of sex workers that's their job. Like that they have decided to do, and
plenty of them make more in a month than I make in a year, and in fact, some of them make more in a month than I may make in my lifetime.
and so that's part of the reality. So is it unreasonable, or should somebody be legally liable, even worse, criminally liable, if they don't kind of confirm the bona fides of the consent? Or can they even contact the person to determine? Should a platform be liable if somebody posts something that they have no knowledge of who it is or kind of where it came from? Should we have a diligence requirement or a due diligence requirement with respect to confirming that? Some of this becomes completely unworkable. And we're about to see, this is kind of setting the stage for, we're very likely to see this current federal government introduce a bill in Parliament in the next little while related to what they call online harms, or what they started calling online harms, and now they're calling online safety. Introducing intermediary and platform liability and kind of takedown obligations within 24 hours. At least that's what they were talking about, which means that the default position for a platform, if they were acting rationally, would be to take
down everything.
Take down all the things, which is an interesting way through the back door of enforcing provisions that you'd never be able to get in a court. You could never get a court to order most of that stuff to be taken down, or a lot of that stuff, without determining really what's going on here. We're not going to issue an order without understanding the context. But if all you need is one person to complain, then the easiest thing is just to take it down, because you don't have the opportunity. You don't know who the person is in that image. So it just needs to be properly tailored, because my concern with the situation in Nova Scotia and the situation with the criminal code and now with this is that if they don't get it right, it gets thrown out. and it's not there to help the people that it was intended to help.
And reading this, I don't see how it survives. I mean, we've been talking about the Oakes test, and a lot of people who are viewing this might not know what the Oakes test is. So I guess for the viewers, the Oakes test is after the case, the Queen, as it was in Oakes, which is the test for when the government can justify a law that limits a charter right. So if they want to have a law that limits freedom of expression, which is what we're talking about here, what is the test as to whether or not that is something that is within their power? And so it's got basically 4 parts. And that is, first, it's got to be a pressing and substantial objective, which means it's got to be important and necessary. Governments almost always win that, because usually the government can always find something to point to, right? But I mean, in theory, if you had it where the government was trying to regulate things because they were just like, for the purposes of aesthetics, we don't like this, the government could yank it on that basis. But the government's never going to say that. The next bit is sort of a proportionality test, which is, first, it's got to be rationally connected to the law's purpose. Usually the government sort of survives this, but if something just makes no sense in terms of how it's connected, like, then they may not be able to succeed at that. Next, it's got to minimally impair the right, which means that you can't say, if you have something that's really important, it doesn't give you carte blanche. So just because you might say that this is something that affects people's ability to be alive, right, their actual life, that doesn't mean that you can pass any law. It's got to be narrowly sort of tailored down to what it's going to do. And the third bit is a proportional test. So the effect on the charter rights has to be justified by the benefit, basically. It's a kind of a balancing act on that.
Yep.
So all of these laws, because they're aimed at affecting people's expression, right? This is expression. Even bad, like, the court has been clear that even really bad expressions are part of freedom of expression. They just might be justified. So
all of it short of violence kind of goes into that analysis. And if it's determined to be low value content, that it's kind of disassociated, detached from, distant from what are called the core of charter values, then that goes into the final balancing. Well, really, what are we limiting? Are we limiting stuff that's kind of core political expressions, core self-actualization, or are we limiting something that's kind of expounding demonstrable falsities and those sorts of things? One thing also that in the Oakes test in section 1, it has to be prescribed by law. And there's have been some cases, and I'm not sure this is guilty of it here, but there have been, in the Nova Scotia case, it was, where the definitions are so broad and so vague that they don't create a discernible standard for kind of behavior expectation, that it can't even said to be prescribed by law. And so this is
because when it's that vague, it's basically just, what do the law enforcement people feel like using it against? Because it could be used against anything, or nothing. Right?
But kind of, does it prescribe a standard that can be applied by a judge in a rational, consistent basis? And if it doesn't, it can be thrown out on that basis. So it's a minimal impairment. It's kind of, does it catch stuff that's not connected to the actual rationale for the legislation, assuming it's pressing and substantial. So if it catches too much, it can be thrown out.
And here we get to a part, this is where I started thinking, like, this could have been written by the porn industry, because we have the reasonable expectation of privacy aspect. And it says, for certainty, an individual may have a reasonable expectation of privacy in, 1, an image that has been altered, and 2, an intimate image in which the individual is not identifiable. That's not, I mean, that's sort of, we're still talking about if you blank out the face, that's still potentially covered. But here we get this, a reasonable expectation of privacy in an intimate image is not lost only by reason of A, distribution of the image by the individual, B, consent of the individual to the image's distribution by a person other than the individual at the time and to the extent of that consent, or C, or 3, death of the individual. So this, I thought, was just wild when you start thinking about it, because this could be really used as a copyright infringement aspect. So let's say, for instance, that somebody does a porn film and it gets distributed online via a porn site, and somebody downloads that video and then shares it on some other site. When we really think about it, the issue at that point isn't that the privacy has been violated, because the person who filmed that porn, like who participated in it, assuming that they were a consenting participant and all of that, they expected that this was going to be distributed to a potentially unlimited group of people.
Yep.
But they expected it would be distributed through a particular platform. And now we have this issue of, if somebody infringes copyright, are they violating this? And is that something that makes sense? I think that this is a problem for this in that sense.
Well, and you combine it with the fact that it can be revoked. That whatever consent that they might have given previously could be revoked. And so, like, one example that I can think of, there's a politician.
So this is this section here.
Yeah.
You can revoke consent to that distribution at any time. And if you revoke the consent and communicate that revocation to a person who distributed the image, they must take every reasonable effort to make the intimate image unavailable to others.
Yeah. And so I have a firsthand example of that. So we have a politician from Nova Scotia who was formerly an actor. She appeared nude or semi-nude in a TV series, a very popular television series. And when Nova Scotia is the legislation that was ultimately found to be unconstitutional, when it was enforced, some young teenagers found screen caps or images from that broadcast that was on HBO or something else like that, widely distributed, that showed her without her top, and tweeted it. And she called the cyber cops, claimed it was cyberbullying. And a whole bunch of stuff kind of came out of that. But if you look at it in this sort of context, or through the lens of this particular provision, somebody who has, in connection with a multi-million-dollar Hollywood production, kind of signed away, and presumably, knowledgeably, probably with a manager, hopefully with legal advice, had signed a waiver and a consent related to that production. Should they be in a position to revoke that knowledgeable, informed consent later in a way that would undermine the distribution rights of the company that invested $1 million in making the show? That surely that can't have been the legislature's intention. But it would be captured in that if one of the actors who appears in it decides that I'm going into politics now, and I don't want these things on the internet anymore.
Well, or not even just that. Hey, we filmed this movie together. It's a $1 million film. People still love it. They still watch the heck out of it. But I've run out of money.
Mm-hmm. Yep.
Hey, big production company. I want another 500 million out of this. You guys are making billions a year out of it. I would like some more money, and I will revoke my consent for it to be shared unless you pay me some more money. Yep. And they can come back to that well as many times as they want, according to this legislation.
Yep. One thing to note, just as a practical matter, is that, and we saw this in the Nova Scotia legislation, and we're the same issue is going to rise into the BC one, and Alberta has it, Saskatchewan has it, and others, is that, those an order of the Court of British Columbia does not travel outside of Canada under this statute. Yeah. That in order for it to be recognized, for example, by a court in California related to a Hollywood studio, or in the Valley related to a adult entertainment, they would have to try to domesticate it. And among the principles of domestication of these sorts of orders would require that there be an equivalent in that particular jurisdiction. And California does have a revenge porn and intimate images civil claim. I don't know whether it includes an injunction. I'm not sure whether it would be parallel, but certainly one of the things also to think about the just the utility of these sorts of laws, which I think have been very useful. Don't get me wrong, is that they might give people too much hope or expectation that certainly a respectable online large platform like the social media companies that we might think of that would be kind of top of mind, they're going to voluntarily follow an order from any of these tribunals or any of these sorts of courts. But there are websites that are purpose built for hosting this sort of non-consensual pornography. That's their reason for being, and in fact, they make money by forcing people to pay to take it down. And they're not going to honor a court order from Saskatchewan or from British Columbia or from Nova Scotia. Yeah. So you'd have somebody who go through a significant process, thinking at the end of the day they're going to get a piece of paper with a court stamp on it that's going to solve their problem. And so expectations, I think, need to be properly set.
I mean, realistically, for a lot of these things, once they get out to a sort of certain level of in the wild, you will never get them back. Like, you can not dial that back, because there's going to be thousands of people who collect these things and repost them, and they're sort of like wells of reinfection across the planet.
Yep.
And nobody has the ability to pursue somebody, including into jurisdictions where, like, the person might be in Malaysia, and I don't know what Malaysia's privacy laws are like. Yep. But how much are you going to spend to get a separate judgment in Yep. Malaysia? And then also you've got to do the same thing in, everywhere. It's just not feasible. And each time you whack one mole, there's going to be 3 more that pop up.
Well, and the perfect may be the enemy of the good. That if it's kept off most of the most notorious platforms that are making a fair amount of money in whatever industry that they're doing, and have something at risk, then that will probably deal with a significant portion of the possible viewership of this sort of stuff, and will go a significant way. And so I don't think we should just kind of give up because there might be somebody in Malaysia or the Philippines or someplace kind of beyond our reach. But we do have to be realistic in terms of this. This is never going to be the silver bullet, and certainly there are loads of politicians who will stand up, and we saw this with the criminal code amendments in the Protecting Canadians from Online Crime Act, where the Minister of Justice at the time stood in the lobby of the House of Commons with the parents of Rita Parsons and Amanda Todd, saying that had this law been in place, that those 2 young women would be alive today. Where, had the police actually enforced extortion and child pornography laws at the time, and luring laws at the time, their children would probably be alive today. And so, I rarely say there ought to be a law in this area. I do think that there should be one, but it needs to be really, really appropriately tailored for the significant problem that does exist, in a way that doesn't go so broadly that it imperils the legitimate interests and the legitimate expectations for a piece of legislation like this.
That was kind of my take on reading this, is like, the idea of having a law to address this is not a bad idea. This is a bad law, is my read on it. And the other thing, I like this, they're looking to do this in BC. BC's got a substantial film industry. And in fact, they keep trying to woo companies over to, to film there. And filming the movie in that area may give enough of a grounding for a civil judgment.
Yep.
So why would you ever film a movie in British Columbia if it might run afoul of this?
Yeah, certainly anything above PG rating, I would be, if I was advising the movie studio, I would be mindful of this, and I'd be saying, about it.
I'd be saying, if there's nudity in it, I'd be saying, nope. And even if there's, because sometimes they'll have like a double for, so there's, it's not actually the actress's, body, it's somebody else who's standing in, because they do various, even that, you're like, nope.
Yep.
And in that case, it's worse, because now you've got 2 people who could potentially want to revoke their consent. And you go, oh, even though in the movie, it looks like it's this person, it's actually this other person nobody's ever heard of. And that actually raises the possibility that bringing one of these claims could in fact end up being more destructive, in the sense that if you are the body double in one of these things, you're going to be some tiny entry in the credits.
That's right.
But once you bring an application, now you might raise more interest. You can Streisand yourself, or Streisand affect yourself into some real trouble on that.
Right. And you can just block the distribution of a whole production. That I can't imagine was the intention of the legislature, but is the, it's one of those things that I don't know whether the legislative drafters just really didn't do well in the lockdown and haven't recovered that well, or like we've just seen a whole bunch of particularly internet related bills that are like, okay, well, it's headline grabbing in terms of what it is that you're doing, but when you actually get into the nuts and bolts of the drafting the language in the bills, it's like, do they really know what it is that they're doing, or do they care?
I feel like a lot of these bills, they either know that they're giving themselves too much power and are okay with that, or that they got a bunch of people who think they understand the internet because some lobbyists explained it to them and they can check their email and don't really realize just the problems. Are you familiar with Eliza Blue?
I'm not.
So this is a recent Twitter controversy. I would play the video, except she's actually super, she's been taking down everything sort of already, which in some ways kind of shows that maybe this isn't as necessary, at least for the major platforms, because the major platforms already typically have policies around, you know, revenge porn, non-consensual intimate image sharing, and in many cases, the sharing of any intimate images, right? Facebook doesn't let you post bare genitals under any circumstances, whether it's consensual or not. But she was sort of an activist in sort of the anti-porn, anti-trafficking genre, and had an elaborate sort of tale of her trafficking experience. And people were pointing out that her timeline doesn't make a whole lot of sense, because during times when she was saying that she was, you know, in various sort of states of mind or states of whatever, she was filming music videos that were highly sexualized. No actual nudity, but you don't need actual nudity for this necessarily. So that this would have been an excellent weapon for her, notwithstanding the fact that it seems to me that the commentary was very appropriate speech about a political figure. Like, hey, your story doesn't match up because look at these videos. I also kind of wonder about how they're going to handle reasonable expectation of privacy in some of these photos. Because, for instance, if you're on a beach, the things that might be acceptable to view on a beach might be very different than if you're, you know, so that creates issues. It's all of this is sort of chaotic here, but there's a process for making an application whereby you can order somebody to delete or destroy all copies of the image in the person's control. Which, again, if you're a film studio and you have to destroy all copies of your film, that's a thing. And making it unavailable by having it removed from any platform operated by an internet intermediary and from other electronic form of application, software, database, and communication method, and having the intimate image de-indexed from any search engine. And keep in mind, I mean, we sort of already covered this. Some platforms may be like, we don't recognize your order.
And some platforms will take it down as a matter of policy, and some platforms will say come back with a court order and we'll follow it voluntarily. And so there is a bit of a spectrum. I think we're going to definitely have a whole lot more discussion about this and internet intermediaries when this online harms or online safety bill is introduced in the next year or so.
And there was also that discussion of the there was that liberal minister who repeatedly appeared on video with his colleagues naked. And one of the politicians shared an image from that and immediately had to take it down, and because people pointed out that might actually have been a criminal act. Which, to my mind, a politician showing their tackle to their colleagues is kind of that's kind of important political news.
And you see in this bill, if I recall correctly, the fact that somebody is a public figure is irrelevant.
Which
I can get at in a certain sense. So if somebody is a well-known actor or actress, they still have a privacy interest with respect to anything that they do in the intimacy or the privacy of their own home, for example, or in other places. But with respect to, I don't know, if you were to find a politician relieving himself in an alley after a drunken night out, for example, and you were to snap a picture, that would be a non-consensual intimate image.
Or say, you could have a picture of something even worse.
Yep.
Like, hey, this is my Ring camera image, and this politician was on my front step touching themselves, in blackface. And you're like, this is super newsworthy. And I mean, there's not a lot of politicians that might do that, but you might say this is super newsworthy, and nobody can cover it.
Yeah, so I'm not seeing enough guardrails in here in order to kind of take that sort of thing, the newsworthiness, into account. Now, there is something in here about the public interest, and we see the public interest referred to in the criminal code in a number of circumstances related to obscenity and other things like that. But there's I don't think that's often used, and I don't think there's a whole lot of guidance for a judicial decision maker to determine where is that line. Certainly they would have to take Section 2B into account. They would have to take into account the newsworthiness of it and things that at least they should, but it's not expressly there in the statute that they would be kind of required to, in order to provide some sort of comfort to those who are concerned about freedom of expression and hitting the balance appropriately.
I mean, there's a lot of exceptions I would expect to see in this that I just don't see at all. I don't see an exception in this for evidence at a trial. I don't see an exception in this for like study or scholarship, which might be an issue. All of these things are potentially are big problems. It's if you have somebody who's videotaped committing a serious sexual offense, can they then go and bring an application, like a lawsuit, for somebody who shares that with the police? Because that's distribution. There's none of that in there. It's like they didn't think about any of these things.
Unless that's just kind of buried in the public interest thing that's just kind of left there with no definition and no parameters. But that certainly these sorts of things, and I also think just from an access to justice point of view, that these laws need to be as clear as possible in order to, because the people who are going to be reading this statute most of the time are not going to be experienced lawyers like you and me. They're going to be people who are experiencing some sort of really traumatic, potentially humiliating sort of circumstance or some incredible betrayal. And they're going to be trying to make sense of this thing in order to find out kind of what's going on, what their rights are, what their recourse is. And so it's not a particularly user-friendly sort of statute in that sort of way either. And particularly when you're kind of coming up with new areas to legislate in, and we've only seen cyberbullying and intimate image legislation in the last 10 years, clarity is good. Clarity would be preferred, because, and one thing, so certainly there have been cases where these statutes have been used, and there have been circumstances. Certainly the introduction of the non-consensual distribution of intimate images offense in the criminal code has resulted in, there have been a large number of charges that have been pursued and a large number of convictions. And so that's it. I haven't seen like an academic or scholarly review of all of them by any means, but it's being used, and it seems to be being used appropriately. But are these sorts of orders being used appropriately? In Nova Scotia, after the original Nova Scotia legislation was thrown out, in part under Section 7, because you could go to a justice of the peace ex parte and get an order without the respondent even getting notice until they get served with it in the middle of the night by a cop knocking on their door, handing them the order. And that was found to violate Section 7. This bill allows for ex parte orders. and ex parte applications, which I don't think should be the norm in this sort of case. If you don't know the identity of the person who distributed it, then that obviously makes sense. But if you do know, they should get notice and they should have an opportunity to be heard before an order is issued, because that order becomes the status quo. In Nova Scotia, in order to, so the pendulum swung completely the other way. You have to bring an application in the Supreme Court of Nova Scotia, which requires the victim of these sorts of things to fill out a notice of application under civil procedure rules, get an affidavit drafted and sworn, filed, buy a law stamp. I don't know anybody self-rep knows where to get a law stamp or even understands what the hell one is. And so we need to be kind of mindful that the barriers aren't so low that it's just a kind of on a whim, or that it's so high that it's not going to really be of any utility. And so you just end up with the existence of the statute being window dressing in and of itself.
Yeah, and I mean, we can look at the defense to, the defenses here are real sparse. Yep. Had or honestly and reasonably believed, which is, of course, going to be, it kind of puts an obligation on you if that the respondent had the consent of the individual depicted in the intimate image to distribute the intimate image at the time when and to the extent that the intimate image was distributed by the respondent. That can be, depending on how they interpret that could be all sorts of things, right? Especially this, again, seems to be aimed at a lot of the copyright violations, because it's like, oh, did you know you were violating copyright? Well, yes. Okay, then you're out on that one. And B, or B, the distribution was in the public interest and did not extend beyond what was in the public interest.
Yep. And
that one, I mean, that's both vague and narrow at the same time in its own ways.
Yep.
And
so like a prime example, the politician caught in flagrante delicto in doing whatever, put it on the front page of the newspaper, reproducing the image, one could say, goes beyond what's necessarily in the public interest, because you could have just reported on the fact of it. And so kind of where in fact is that line properly drawn? That, oh, well, a politician was captured on camera doing this, rather than, well, put up the image and you'll know for sure. That defense in section 11(1)(a), if the consent can be revoked, you'll see that the wording talks about kind of at the time, right? At the time when and to the extent the image was distributed by the respondent, that it can be revoked subsequent to that. And so, well, until it was revoked, I thought I had a good faith belief that I had their consent, but the onus is on me to prove that. Presumably the person bringing the application is indicating their revocation of consent. And so anything after the point that the claim is brought is vetoed. So.
Yeah, I mean, this is there's some real sort of issues on all of that. This is kind of not in the legislation, but something I just wanted to, or just was thinking about. Eventually, I imagine they'll probably bring in something aimed at deep fakes. And it seems to me this is going to end up being a major area of contention. Because if you, like, let's say you go to an AI and you have it do a simulated face of somebody, just that face is going to look like someone out there, because there's, so long as it looks like a face, there's going to be someone that looks like that, because there's just so many people. So what happens if you end up with somebody who generates an image and shares it out there? Like, say they've got a porn site that is just like, we've got an AI that produces porn images. There are no people involved. We don't feed it, like we don't want it to come up with anything that looks like a person. They're just kind of randomized images. But eventually it happens to spit out one that looks just like Bob, and Bob's friends, see it and start sharing it and going, doesn't this look like Bob? At that point, is that going to be the kind of thing we want to capture? Like, just kind of random chance? Or and if we're capturing like images, I mean, there's a lot of people out there who, since the beginning of like art, have drawn pictures of people nude. Like, there's a number of like Victorian nudes that were drawn from, I saw this girl at a party and I painted a nude. And she never took anything off. It was just the person painted a nude of what they imagined that she looked like. It's weird that things that are sitting in a gallery might be illegal if you did it now.
Yeah, and I think that's something they're going to have to deal with. That I've seen. So I'm not sure what the website is called or something. I've seen some people tweet kind of, this person doesn't exist, and it's essentially, it's like stock photo that uses AI to create like a generic person, and it's photorealistic, and so you look at it and you assume it's a person, but it's not of a person. It's a composite of a whole bunch of, oh well, most people have two eyes, a nose, and a mouth that looks like this, but they look like actual people. So there will come a time when that will look close enough to probably a dozen other people who actually exist. Yeah.
And if anyone watching this looks like this is generated by thispersondoesnotexist.com.
Yeah.
And we can just get tons of these. Like it's got a, here's another one, right? And it's just, it'll just keep spitting them out as long as you just keep hitting refresh image. That one maybe I'm gonna have to be careful because it might spit out something weird. But
but I think what you just talked about, I think it is a reasonable concern. But I think there's probably a difference. And again, this is the challenge of line drawing in an area like this, where you're doing it in a speculative sort of way, because you're anticipating problems and you're trying to come up with the rules to deal with them, and so you need to be careful about the unforeseen consequences. But I would say there's a culpability difference in terms of using deepfake technology to create something that looks like somebody that you've asked it to look like, and you've then distributed it. And, as you know, kind of the law often distinguishes between possession and distribution when it comes to things. And probably the law should distinguish between those two categories. I'm not saying both of them are necessarily innocent, but they probably have significantly different consequences for the individual who's depicted. And if the person didn't intend to have it look like anybody in particular, then should that be problematic? Is there any difference between completely legal adult content that exists in Canada that is protected by the Charter, that involves actors, and those that involve nobody other than a whole bunch of silicon on a computer? And one might say that the ones that are completely computer generated are less exploitative for those who kind of look at sex work as being exploitative.
If you hate, if people say, oh, I hate the porn industry because, they, and I mean, I don't have any, the sex work is complicated, but there's plenty of people who are in it by choice and who view that as an extension of their autonomy. But it's, one of the biggest threats potentially is the ability for, this kind of thing, because give it time and it'll be fairly straightforward for somebody to just tell a computer, hey, this is the image I want, and have it spit out an image. And we're getting pretty close. I also wonder about things like lookalikes, because there have been things where, they're doing porn to, for instance, match, some actor. And they're like, yep, we're going to find somebody who looks like that person. Well, if you find somebody who looks really close to that person, what if your identical twin does porn? All of these things become, kind of, and I feel like the politicians are taking the opposite approach that I would, which is that my approach to this would be, okay, maybe we need some laws, but let's kind of incrementally step up to where we think we've done enough, like by slow progress. Whereas they kind of want to be like, let's just do everything we can think of, and then the law will fail because it's unconstitutional. And
certainly, I would totally advocate for that. I've never seen it done, but to say, let's be specific, very focused on the mischief that we're going after right now. And if we need to expand it, we can do that. We can do that later. But certainly when it comes to the non-consensual distribution of intimate images and what's often called image-based abuse, we know where the real problem is, and we know where the real harm is happening. And we could tailor legislation that focuses specifically on that. And if you find some outliers that still fit within the zone that you think, yeah, this is the mischief that we originally intended to go after, then it can be tweaked later. But yeah, as you said, if you do it too broadly from the get-go, it's going to be found to be unconstitutional, and it'll be out the door, and it won't be there to help anybody.
And I kind of wonder if that isn't the game, because there's something that politicians like to do, which is they put forward this grand law that they know will not hold up.
Yeah.
They wait for it to get struck down by the courts, and then they go, I'm righteous, but look at that big bad court.
Yep.
And that way they get the best parts of both worlds. They get to, point to the court as, you stopped us from doing all this good that we were going to do.
Yep.
But all the bad effects happen only to a few people before somebody challenges it. And basically it happens to however many people it takes before somebody with enough money gets affected by it to take that up to, whatever level of court. And so it's just however many poor people before they hit a rich person. But then
it's often 1 or 2 election cycles in between the passing the legislation, it being struck down, and how many hundreds of news cycles. And so they get to kind of disassociate themselves from the piece of legislation that they promoted. And then kind of people forget about it, then it gets struck down, and then it gives them something else to point at and rail against. And in that case, it's the judiciary. So.
Yeah. So, I wonder how much this is a political game as opposed to something that they actually hope is going to go through, because surely somebody's sitting there going, have you guys not thought about like Hollywood films?
Yep.
Or just the fact that men have breasts, and like you don't actually differentiate between those two things.
Yep. Well, I suppose that the one at this stage, so the legislation, so the bill in British Columbia was just introduced last week, which means it presumably is going to go to a committee for those in the province who live there and can reach out to their MLAs if they see any defects or any ways that it could be improved. That I would certainly encourage people to do that. When Nova Scotia introduced its Cyber Safety Act years ago, the one that was, I called it a dumpster fire in court, but the judge just scaled it back and called it a colossal failure. I had said, I was in the media, I said, look, this is going to be found to be unconstitutional. This is going to be struck down. And I went to appear before the legislature committee, but it was at a time right after a very high profile death of a young person caused by cyberbullying that it was passed unanimously through the House. I'd never seen anything other than back to work legislation pass through the legislature so quickly. And nobody was prepared to listen to a voice of reason. Now, a number of years later, and BC is kind of at the back of the pack on this, they may in fact listen. And from what I understand from speaking to some other people, they did a lot of consulting with people. I'm not sure exactly who, I know a couple, before the bill was introduced. I would hope that politicians in good faith would want to hear ways that it could be improved. I would hope, but
I'm running out of confidence in the good faith of politicians, I gotta say. Like, you've seen Bill C-11, Bill C-18. It's
the misinformation and disinformation that's coming out of the politicians or parliamentary secretaries and their supporters.
They're just willing to straight up lie to get it through. It's this won't affect Facebook. We had them saying, like, it's like, who is it going to affect then, man? It's bizarre, some of the stuff we're seeing, but
maybe I just don't know the politicians in British Columbia well enough to assume they're bad faith. But so hopefully,
it is a different group of politicians, thankfully. But I suspect, I just kind of suspect we're going to see a lot of rhetoric along the lines of what was that infamous line? You're either with us or you're with the child pornographers. That was when they wanted to shut down encryption.
Yeah, that was and Victaves and lawful access to customer name and address and via basic subscriber information, and that they tried to do that a couple of times. The Conservatives did a couple of times, and were actually kind of pushed back by public pressure, and the Liberals did it as well, and pushed back by public pressure. So, sometimes those were the heady days where you felt that your voice might count, and in fact, it did, and so those initiatives never went anywhere. But there's always rumblings in the background with respect to, one of my concerns about this online harms thing is they're talking about a non-production order issued by a cop in order to get, so essentially, lawful access, under the guise of it being related to, of course, protect the children, which is exactly what they did. So the protecting children, or protecting Canadians from online crime, when it introduced the offense of non-consensual distribution of intimate images, most of the bill was in fact new production orders that didn't require reasonable grounds to believe, but required reasonable grounds to suspect, for tracking data, transmission warrants, and those sorts of things. So very often these things are, at least federally, are used as a backdoor in order to kind of get other things that intrude on civil rights, or at least lower the bar in other areas. So,
and if you don't think that these things would end up being used, like misused, I mean, the Supreme Court has basically said any law that goes through will get misused. I think, amongst other things, the case of the Queen and Nur basically said, if a law is only valid because of the notion that you haven't caught somebody misusing it yet, we're going to step in now because they will. So,
well, and the importance of, you had a video a while ago on the recent case related to the kind of the reasonable hypothetical, and the shooting a firearm at a dwelling, and so much of this really does depend on the reasonable hypothetical. What's potentially caught by this, and that's not just important in front of the courts. That's right now important in front of the legislatures and the policy development. It's like, okay, well, what are you potentially capturing within this, because it will be misused, and so put in the guardrails now to make sure that we're not relying on the good faith, and certainly if you have it disproportionate now and capturing too much now, the whole thing will be found to be unconstitutional. So build in those guardrails now, because otherwise that all your effort will be for naught, unless having it struck down was part of their plan. So anyways, we'll see where this goes. And there are a couple other provinces that haven't yet introduced legislation like this, and so and we'll see what people start, if there starts to be a discussion about deepfakes, to bring those into the area. And again, you'll probably have a situation where politicians and policymakers really don't understand the technology and kind of what the issues are. So,
and I mean, some of these politicians and policymakers may find themselves in trouble on their own ends, because, for instance, politicians do oppo research. And you better believe that if they figured out that one of their, rival candidates had, say, done porn, that would go into that oppo research folder. Well, now it can't, guys. Think hard about what you want to do, because this is also aimed at politicians without them really realizing it.
Well, and certainly among the different things that if you were to categorize all the different mischief that deepfakes could be involved in, kind of synthetic intimate images, it's only one category. There's the political disinformation thing, where you could take a politician, and we've seen it done mainly as examples to show what could be done, but you could quite easily put words in the mouth of a politician, or you can put a politician in a completely different scenario that they had never appeared in before, and it would be photo or video realistic. Or
a CEO. I mean, there's all sorts of ways you could do that, to like, hey, I'm going to short sell Tesla stocks, and here's a deep fake of Elon Musk kicking a dog. Or Elon Musk drunkenly saying, like, I'm going to sell this to, whoever, like Huawei. And then suddenly, the stock goes in whatever direction, and you're sitting there going, you can be sitting there cashing in. We also see a lot of extortion threats. And this is one of the places where it's like, because a lot of the times when it's like, shouldn't there be a law? You mentioned this before. Often there is a law. In the case out of Nova Scotia, there, the sort of really famous one, I'm now I'm blanking on the name, even though we've said it several times in this.
Rehtaeh Parsons or Amanda Todd?
Yes, yes, Rehtaeh. It was, they could have proceeded with, extortion charges.
Yep.
And there's so many situations I've seen where, in some circumstances, I've tried to help people who've been victims of that kind of thing.
Yep.
And sometimes it's really difficult to talk to the cops and be like, listen, you have text messages from this person threatening to engaged in an extortion, sometimes literally for money. Like, you will pay me $2,000 or I will send these pictures to your mom. And it's like, just go there with a warrant, take the electronic devices, and you can, lay charges. It's not hard. And they're like,
in the two highest profile cases we've had in Canada, Amanda Todd and Rehtaeh Parsons, it wasn't until after both young women were dead that that by all appearances, the effort went into investigating and prosecuting. The person accused of and now recently convicted of extorting Amanda Todd was from Holland, was extradited, was charged for a whole bunch of people that he'd harmed in Holland, and then arrested, charged, and convicted in Canada, back in Holland serving a sentence. The two young men who were immediately involved in the assault and photograph of Rehtaeh Parsons weren't arrested until after she had died, and they reopened the investigation. Whereas everything related to that investigation had to do with things that were in play and were real things to investigate while she was still alive, but they didn't. And so some significant problems. And that's one of the things that by kind of spelling out the offense and spelling out exactly what is in there, that you signal to the cops, they at least have something they can find in the table of contents of their criminal code, because they don't necessarily, at least in my experience, I think it parallels yours, they don't have the imagination to say that extortion takes place regardless of the technology used.
The problem is that sometimes it can actually short circuit that thinking. Because what I've seen is officers say, oh, well, there's a charge for distribution of intimate images. This guy's only threatening to do it, and he hasn't done it yet. So wait until he sends the pictures to your boss, to your parents, and post them online where you will never get them taken down. And then we can do something. And it's like sitting there being chased by somebody with a knife, and the cop's like, I'll get involved once he stabs you. And you're like, not good enough, please. I've seen that a lot of the time, where they're sort of short-circuited by the intimate images charge to fail to deal with the extortion. And the extortion's a real serious charge.
Oh, it absolutely is. Yep. You can also get a peace bond for threatening to distribute an intimate image, but that's kind of buried in the peace bond provision, so it's not that well known to the police. But so I think that getting a little bit further afield from the original conversation, but I do think that we would, as a society, benefit from greater training of the police with respect to technology that is being used in everybody's day-to-day life. That you can't make it out of the police academy without learning how to drive a car, but you can make it out of there without understanding kind of how the internet works. So
I deal with firearms. Similarly, you get police officers who don't know, they have a vague idea of which end goes bang. It's kind of the same problem, right? So this one, I look at it and I go, I think we're both in agreement that I don't see how this one survives. There's just too many, it's too broad. There's too...
certainly. If somebody's prepared to challenge it, I think it would ultimately crumble, and all it would take is somebody to challenge it, but or somebody to try to wield it around as a threat with respect to the sort of thing you talked about kind of a movie studio being threatened with a takedown order, and they would probably put a significant number of expensive lawyers on the case to have the whole thing struck down. So
Sharon Stone has quite famously said that the scene in Basic Instinct, everyone knows the scene. I'm not going to roll it here, but she said that was done without her permission. There's arguments on both sides as to whether or not that is something that should be shared if that was done. But at this point, taking it down isn't going to solve anything.
Probably not. Yep.
And it's just, but what if she goes and says, I don't want this distributed in British Columbia anymore?
Yep.
Because you can get this order against like ISPs and so forth. Like, what if she goes and says, I just want to, I know I can't affect the movie studio, but I can affect, TELUS, and they have to block this, or Netflix's Canada division, they've got to take this video down.
Yep.
Just, I could see that being a sort of situation where this law finally gets challenged. It's, as I said before, it's just how many poor people do they run over before they hit a rich person is really what this is going to come down to.
Yeah, no, I think that's a pretty good way to kind of cap this off. That's the way a lot of this works. So,
all right. Well, thank you for joining me. I will probably tack on later a little sort of out introduction kind of thing, and the Patreon and all that stuff. You don't need to have me read through all of that. But thank you again. Let people know where they can find your stuff, because you've got a lot of good stuff out there.
Yeah, well, thanks for the opportunity. Yeah, so I've been on the internet for quite some time as an internet and privacy lawyer. I have a blog at blog.privacylawyer.ca, but most of my creative energies are going on to my Twitter and my relatively new YouTube channel. So you can find me at youtube.com/@privacylawyer. Try to post a new video every couple of weeks, mainly related to privacy and tech law issues. Some of it targeted, most of the work I do is for companies, so some of it is targeted to kind of in-house lawyers, but some of it is for a more general audience in terms of understanding the fundamentals of the weird and wacky privacy laws that we have here in Canada.
And yeah, so if you want to understand, for instance, like how companies can use your information and that kind of thing, which, I mean, if you're on the internet, there's companies using your information in various ways. Check it out, because I think that a lot of the privacy stuff is going to be potentially the biggest issues as we go forward. But
yeah, certainly never a dull moment in this area. But one of the most popular videos on my channel is, and I understand why, relates to recording the police in public. People often have questions about that, and police misunderstand what their powers are in that area. And the use of surveillance cameras on your personal property, which people often have questions about as well. So those are pretty easy to find,
and often misunderstand. Like, and especially because a lot of the advice doesn't cover a lot of the circumstances. Like, hey, you can have a surveillance camera on your property. Good stuff, but that doesn't mean you can necessarily aim it into your neighbor's bathroom window. That's a different.
That's right. Yep. Living room window, maybe. Bathroom window, definitely not. So, yep.
So check them out. That's where you can find all the answers to those kinds of questions. And thank you for joining us, and see everyone next time.
Thanks, Ian. Take care.
And just a quick interjection to thank my Patreon supporters. At the $50 level, the CCFR, David Michaud, Canada's National Farms Association, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited, and Jane Babe and Luxor. And at the $20 level, Lindsay Metcalf, Kyle Fox, Haywire, Gerald to the Bailey, Cameron Johnson, Andrew Elsich, and Vicky. Thank you as well to the $10 supporters who will be in the crawl immediately following. Thank you guys for watching. I hope you guys enjoyed this as much as I did, and see you next time.